information specific to San Francisco and San Jose. So if you could kick things off by commenting in the chat or the Q&A box your location. We do have information on SF, San Jose, and Oakland. And if you're in those three locations, just comment in the chat box so that we know that we're covering everywhere that's relevant for folks who are on the call. And just before we get started, I want to make clear up front that this is meant to be informational. There is no legal advice intended in what we're sharing, just trying to give tips and tricks on the negotiation side, but then also just provide the information that's out there on protections in the three surrounding Bay Area cities. The Lawyers Committee is offering commercial lease consultations, and so you can sign up through LCCR for one of those, and we'll talk more about that at the end of the presentation. As far as what we're going to cover in the next hour, we'll go through first steps before you begin negotiating with your landlord. We'll talk about the relevant protections that are in place right now in relevant cities based on your responses. And then we'll also talk about tips for negotiating with your landlord. So when you're beginning this process and have just started to think about talking to your landlord, really the first step is to review your lease. So if you have a paper copy of it somewhere, if you received it in an email when the lease began, track that down. Make sure you review the whole thing as well as any exhibits or appendices. If you sublet the space from someone and have the original lease that the subletter signed with the landlord, it can be good to review that as well. If you've extended your lease for multiple terms and there was a lease addendum or other document that was signed to indicate that, it can be helpful to see if any of the terms of the lease were altered in that extension document. And in reviewing all of these primary lease documents, exhibits, appendices, it's good to keep an eye out for certain provisions, and we'll talk about some of those now. One of those is common area and other shared expenses. If there's a common hallway, common entryway, where you share expenses for janitorial services, utilities, different things like that, you want to know what your full obligations are under your lease. In terms of the negotiation process, it's helpful to look for some of these items in terms of possibly using them as leverage for rent reduction. So the first is any abatement provision or other rights that you have. If there's any limitation on your access to the building that's occurred since the shutdowns began in March, not only have you been shut down by the government, but your landlord hasn't allowed you into the building, that could be a ground to cite for reduction in your rent. And the same thing for if the landlord has cut off services. So if your utilities have been shut off, if different janitorial or sanitation services have not continued during the shutdown, all good things to keep in mind. Some leases, I have not come across any yet, but some do include a force majeure clause. And this is something that is known as an act of God clause that would give you protection from paying rent during an act of God. Normally that would be a storm, an earthquake, something that interrupts your business. But in this case, we have a pandemic. So this is something obviously that was an act of God, not done intentionally by you or anyone else, and it's affected your business. So keep an eye out for those two words in reviewing your leases. There could also be provisions that guarantee your right to access or use the premises. So this goes back to any interruption in your ability to access the space separate from the government mandated shutdown. That could be a way to get a reduction in your rent. A lot of the California leases have what's called a condemnation and or a casualty provision. This is designed to cover a loss of access or use during a governmental action. Usually this is a situation where an interstate's coming through and the building is being taken over through eminent domain. But if there's language in there relevant to governmental action that could be interpreted in the context of the pandemic, that could be helpful. So even if you're not quite sure what it means, it can be helpful to go through the lease and just flag these items that we're talking about to possibly talk to a lawyer about later, or to sign up for one of our commercial lease consultations. If you are in a building that has multiple commercial spaces, like a food court or a shopping mall, a larger building where you just rent one room or portion of a larger floor, there may be clauses in your lease that require your landlord to maintain a level of occupancy or have certain stores in operation. And if the landlord has failed to meet these requirements, that could be a justification that would trigger termination or give you other rights. So another thing to mark if you're catching that language during your review of your lease. Some other language to mark or just make note of: quiet enjoyment rights, which you have a right to quiet enjoyment of a space that you rent as a commercial tenant. And if there's been any interference with that, again, possible ground for negotiating with your landlord. If you paid a security deposit on the space, there may be requirements that if the landlord applies it to miss rent, for example, you have to pay the deposit back within a certain amount of time, or it may not need to be replenished or repaid at all. So just keep an eye out for paragraphs discussing the deposit and what the requirements for that are. Outside of the lease language itself, there may be other grounds that you could point to, such as supervening illegality. You're not able to operate your business legally because of the government shutdown. And so if there's a requirement in the lease that you operate a certain number of days a week and a certain number of hours a day, you weren't able to do that because the government forced you to shut down. And a lot of leases actually have provisions that require you to abide by government action or orders, as well as state, local, and federal law. So another provision that you can keep an eye out for during your review. And if there's any habitability or possession provisions, some of which we've touched on a little bit, just keep an eye out for those. There may also be an argument for commercial frustration of purpose, in that there was no way for you to actually carry out your business because of the shutdown. So all things to keep in mind when you're reviewing your lease. After you've done that, the next thing you're going to want to do is to notify your landlord, and to the best of your ability, keep an open dialogue. A lot of the commercial eviction protections that we'll talk about in a minute are going to they're going to require that you at least notify your landlord that you're suffering economically from the effects of the COVID crisis. So at the bare minimum, even if you're struggling to have a positive line of communication with your landlord, at least provide notice to the landlord as required, so that you're checking the box to meet the requirements to qualify for these protections. Even if your landlord doesn't respond, as long as you have a record that you've done your taken your required steps, then you've done the minimum that you have to do. Along with that, save everything in terms of correspondence with your landlord, copies of your lease, any other written correspondence prior to COVID that you have about the lease or the space, as well as any hard copy letters or notices that you've gotten from the landlord since COVID began. That can include emails, text messages. You can take a screenshot of text conversations and kind of scroll through and screenshot each part of it, and voicemails as well. It's good to have records of all of those communications, especially if the landlord's being difficult, so that down the road, if you need to show that the landlord wasn't willing to work with you, you're going to have multiple examples that you can show to a court or a mediator, depending on where the negotiations with your landlord end up. And I know we went through that sort of quickly. You will get a sort of summary of the contents of the presentation so that you can go back if you have questions. and sorry for not noting that at the beginning, but you won't need to necessarily take word for word notes on what I'm saying because you will have access to the presentation contents. But if you have questions so far, you can pose those in the Q&A, and Anna can pose them so I can answer. Quickly, then, if anyone from San Jose is on the chat and can just state that, I don't want to cover information that's not going to be relevant to folks, but I don't want to miss anyone either. But we'll go ahead and go into Oakland. So Oakland's commercial lease moratorium, probably heard that word, but that's what the protections for residential and commercial leases in terms of eviction protection are called. And Oakland's eviction moratorium is actually tied directly to the statewide order from Governor Newsom. And so at the end of September, Governor Newsom gave cities in California the authority to extend eviction protections through the end of March of 2021. Oakland, fortunately for commercial tenants there, extended it for the full allowed time period. And so through March 31st, commercial tenants in Oakland are protected from eviction under Oakland's moratorium. This applies to commercial and small business tenants as long as they have 100 employees or fewer, and includes all nonprofit organizations. Qualified businesses that meet that definition can't be evicted for non-payment of rent that was caused by a substantial decrease in income caused by COVID. We've had questions before in terms of what a substantial decrease is. It is not defined by the city, and so if you've seen a drop-off in business and foot traffic, if your receipts compared in February compared to end of March or April, you see a significant reduction or substantial reduction. It's sort of in the eye of the beholder, but as long as it's a sizable decrease in business, you would qualify for that protection. So what this protection does is it provides a defense to any landlord attempt to evict you for not paying rent. Other issues, nuisance and things, it doesn't protect you from everything, but if you're unable to pay rent because of the economic effects of COVID, you're going to be protected from eviction through the end of March of next year. Key things to keep in mind during this period is that rent, right now anyway, missed through that time period would be due on April 1st. So it's good, even while you are not having to pay rent, to start that process to talk to your landlord, work out some sort of repayment plan so that you don't have a huge chunk of back rent that is coming due the day after the moratorium ends. The protections in Oakland may extend after the state of emergency ends. We'll have to wait and see how the economy recovers and the state recovers and what the government at the state level and local level do. We'll see what the federal government does here in the next couple of weeks. If the deal that they keep talking about actually goes through, there could be other relief there. Moving on to San Francisco. So San Francisco is similar to Oakland, able to extend its protections through the end of March next year, but has been issuing its extensions on a month-by-month basis. So the end of every month, it's been extended for another 30 days. Fortunately, the city expanded its protections for 2 months at the end of September. We'll see if they go back to every month or every 2 months, but it gives folks a little bit more peace of mind and they're not waiting with bated breath at the end of every month to see whether it's going to be extended or not. San Francisco's moratorium applies for rent that was missed starting on March 17th of this year and would go through November 30th. So as long as you've missed rent during that time period, you've been financially impacted by the COVID-19 crisis, you are registered to do business in the city, and your gross receipts for 2019 were at or below 25 million, you are qualified for eviction protection as a commercial tenant. This does apply to the qualified commercial tenants, subtenants, and month-to-month or holdover tenants. So as long as you were one of those four when the crisis started on that March 17th date, then you qualify. And it's important to note that you're protected from having to pay rent and being evicted for not paying rent during that time. And rent is an expansive definition. So it's not just your monthly rent, it's any additional rent, which a lot of leases include, and that may include common area maintenance fees. It may include your security deposit, and then late fees and interest are also part of that. So the landlord can't say, I know you don't have to pay rent right now, but I need you to pay back your deposit, or I need you to pay the CAM fees, or you still have to pay me the late fees and the interest, even though you don't have to pay rent. The landlord can't require any of that from you while the moratorium is in place. To claim protection under the moratorium, if you qualify based on the criteria on the last slide, you need to provide written communication to your landlord. That can be a letter, that can be an email, could technically even be a text. You need to say that you are economically impacted by COVID-19 and you're unable to pay rent for that reason. Some landlords have asked tenants I've met with for bank statements, statements from their point of sale system that shows the drop off in sales. The city doesn't specify what written proof of the economic hardship is. So, the landlord can't demand your bank statement or financial information from you. You just have to say in writing that you're struggling because of COVID and you can't pay rent as a result. This gives you 30 days to try to repay your rent. But as long as you continue to be economically impacted and unable to pay rent because of COVID, then the landlord has to keep working with you. It is helpful to keep talking about repayment terms. If you can pay a little bit of rent, that's going to help reduce the overall back rent chunk that will come due whenever the moratorium ends. But just try again to maintain that open dialogue. And at least every month, at the end of every month, you want to check in with the landlord, give him or her an update on where you're at if you're still not able to pay. And again, make sure it's in writing so that you are able to demonstrate that you qualified. So again, not required to pay any rent during the moratorium. Pay anything you can as long as it is not choosing between not paying a personal bill to pay rent on your space, just because it will help down the road. And it could, paying even a little bit of rent could help improve relations with your landlord if you can. The landlord can, in his or her discretion, agree to extensions. So even if, as a hypothetical, if San Francisco ended its eviction moratorium on November 30th, the landlord could grant you an extension, could give you more time to pay the back rent back. And we'll talk about some ways to try to approach that and ask the landlord for those types of concessions. It's important to note that these moratoria don't include rent relief, so it doesn't mean you have to pay the rent back. It just means you don't have to pay it right now. So definitely keep that in mind. It does prohibit the landlord from trying to modify an existing lease if it was in place on March 17th, 2020. So the landlord can't come in and double your rent or add requirements or obligations that weren't in the lease as it existed on March 17th. So keep that in mind if the landlord is trying anything like that. And importantly, the landlord can't evict you without providing a written notice and giving you an opportunity to pay back the missed rent. And you have to have at least 30 days to do that. But as long as you are continuing to work with the landlord, he or she cannot evict you. So it's advantageous to keep that line of communication open, keep the landlord updated, and try to reach an agreement on a repayment plan. And again, if you haven't paid out all of the outstanding rent on the agreed upon repayment period or after the moratorium expires, and again, some of these agreements with the landlord could extend beyond the moratorium, then that's when your landlord would have the option to pursue eviction. In terms of next steps for San Francisco, I'm sure a lot of you saw this yesterday, but San Francisco is the only big city in the state so far to be moved into the yellow tier of state reopening. It's the lowest level of an infection rate. It's called the minimal infection rate tier. So there's going to be much more reopening for indoor dining for restaurants, expanded capacity at gyms, different things like that. So hopefully that will lead to increased foot traffic, more people coming out, spending their money in the city, and giving more money to small businesses like you all. The pace of reopening is going to continue as long as infection rates stay low. And in terms of local assistance, the Small Business Administration did reopen its economic injury disaster loans. If you go to Google and just search for SFOEWD, there's a page of resources for small business owners in San Francisco. And there are a lot of funding sources on there, many of which are closed right now because they've run out of funding. But as budget years turn over and more funding becomes available, there may be more opportunities to get assistance as the crisis continues. And we'll quickly touch on San Jose. So San Jose, similar to San Francisco, has extended its moratorium through the end of November of 2020 from eviction for non-payment of rent, at least through that time. Once the moratorium ends, the tenants have 6 months to pay back 50% of the rent that was owed. So if it ends as scheduled on November 30th, you'd have until May 31st of next year to pay back 50% of the back rent that is unpaid at that time. And then the remaining 50% would have to be paid back in the following 6 months. And this is something that, even if you're not in San Jose, could be useful for the negotiation process with your landlord. This type of repayment schedule where it's staggered, the first half is due within 6 months, second half in the second 6 months. It could be a good option to use in negotiations to give yourself more time as your business recovers to pay back the back rent, or even longer periods of time. It's all sort of what you think is going to work best for you. San Jose is different than San Francisco and Oakland in that its moratorium prevents landlords from charging you late fees if you repay the rent on time. So that can be a way to get somewhat of a reduction if the landlord's not knocking down your rent owed, is that you can avoid late fees if you repay under that 6 month schedule for each half of what's remaining due. And the landlord can't ask you to waive your rights. So you have rights as a tenant in California and you have rights under your lease. And so they cannot ask you to waive your rights under the moratorium in terms of the repayment schedule, not having to pay late fees, not being able to be evicted. And before the landlord can try to evict you, he or she has to, similar to San Francisco, provide written notice stating the reasons for the eviction. It also has to include a notice of tenant's rights, which is a 3 or 4 page document that lists all of your rights under San Jose's moratorium. And the landlord also has to provide specific resources for rental assistance. So make sure if you receive any notice from your landlord that it meets these requirements if you're in San Jose. And if the landlord hasn't not done that, then it's not a valid notice of eviction. San Jose has also added some teeth to its moratorium in that your landlord could face civil fines and penalties, damages, or other injunctive relief, which is when a court tells a landlord that it can't do something. So you'd come in and say, you can't evict this person, you can't charge late fees, so on and so forth. And that's if the landlord tries to retaliate for you exercising your rights under the moratorium there, or if the landlord tries to deny your rights and protections as a small business tenant. And in this way, you're going to keep the landlord happy because you're meeting the obligations that you made in terms of the agreement, in terms of what you could repay each month. And you're going to avoid repeated renegotiations. So being realistic at the beginning instead of overly optimistic is just going to keep that relationship on better footing. At the same time, don't be afraid to ask for the moon. Don't be afraid to ask for forgiveness of rent, during the time that you were closed, or reduction of rent moving forward, extended time to repay the back rent. If you don't ask for it, you don't know what the landlord's willing to do. And even if the landlord doesn't agree 100%, it could be a way to meet in the middle so that you're getting part of what you want, the landlord's getting part of what he or she wants. There are also options that I've seen other tenants do where they convert the back rent into a loan. And so that is something that's payable over a fixed term. You can do that one-on-one with the landlord. It could be something where you can go maybe apply for one of the SBA loans, which would be something where you could pay off the back rent and then have a low repayment, or talk to your banking institution about doing that. That way the back rent is extinguished, you've got a reasonable monthly payment, and then you can work on what you can pay for rent moving forward so that you're not having to do both. See if the landlord is willing to credit your deposit toward back rent. If you have a sizable deposit that would help reduce the rent that's owed, but maybe the lease requires that you have to pay the deposit back within 14 days. See if the landlord will apply the deposit back rent and give you until after the moratorium ends to pay it back, or some maybe say it has to be repaid by the time your lease ends or something like that. And again, it doesn't hurt to ask about forgiveness, or maybe they can, for the tenant who asked the question about having paid 50% of rent, maybe the landlord could just say, that's all you owe for those months. Thanks for paying what you could. We'll just wipe off the rest and start fresh now that you're reopening. And of course, a promise to pay full rent moving forward could help motivate the landlord to accept that. Again, if your lease term is about to end, you can leverage that to in extending the lease to get a better deal on the rent moving forward. You could say, if you forgive the rent that I missed at the end of this last lease, I'll pay you in full for this new rent moving forward. And it again goes back to, you can walk away from the lease and then the landlord and you will have to figure out how you're going to pay back the rent that you missed through when it ends, say this month. But the landlord's going to have a really hard time finding a new tenant. And so use that to your advantage if you want to stay and the business is doing well. To stay, keep operating in your known location, but also get a deal either on the back rent or the new rental rate, or perhaps both. It also doesn't hurt to ask if the landlord's getting any assistance from these governmental programs. You may get a dodge in response, but if the landlord is receiving some help, maybe he or she will be more open to giving you a break or working with you. And key to making a reasonable ask of the landlord is don't overcommit. You don't want to say, I can pay full rent starting next month, even though the government just said that we can reopen. And I can also pay, $5,000 a month toward the rent that is sitting in the pot of back rent that's unpaid. Try to come up with something that's going to not break the bank. And something that I have talked with other tenants about is tying the repayment, either the monthly rent, the repayment, or both, to a percentage of the monthly revenue. So you could say, instead of monthly rent, convert it to 5% of what you're bringing in for the monthly rent through the end of the moratorium. Or you could say, I'll pay my standard monthly rent moving forward, and then 3% of my revenues can go toward the rent that's owed. And the benefit of that is that it doesn't lock you into a set number. So if you bring in a small amount, there's at least something that's going to the landlord, but it's not taking everything that you've made. And if your business recovers well and gets back to normal, or booms and does really well, then the landlord's going to get repaid even quicker. So it protects you, also satisfies the wants and the needs of the landlord. And again, you could ask to convert the base rent to a percentage rent for a period. At the same time, while you're trying to negotiate and go through this process, don't compromise your sanity. We're all under a lot of stress with everything that's going on right now. If the landlord is being impossible, sending you threatening or harassing texts or making calls to that effect, do what you have to do to qualify for the moratorium in your location, and leave it at that. There will come a time down the road, where the landlord may try to evict you or those kinds of things, and hopefully there will be lawyers involved that can kind of funnel through that hostility. But at least, for now, do what you need to do to qualify for your moratorium in your location, build your business back up, and hopefully by that time you'll be able to start repaying the rent, and maybe the landlord will change his or her tune. So in terms of next steps, I already talked about reopening in San Francisco. It's continuing all throughout the Bay Area. I mentioned that courts have not had a chance to really look at the eviction cases so far in terms of how they're going to interpret these lease provisions against tenants. How they're going to view landlords that have been demanding that tenants pay half rent or full rent during these moratoria terms, where the law said that the tenant didn't have to pay anything, and the landlord still was demanding that the tenant pay rent or be evicted. So I think courts are going to definitely have some opinions on the reasonableness of landlords and how much they're going to be willing to give them in terms of rent that's owed. In terms of federal stimulus and action, the House did pass an updated HEROES Act at the beginning of the month. The White House and Congress are still in negotiations. We'll see what comes of those, but there could be more stimulus. There could be more relief for commercial and residential tenants. Keep an eye out for that. And there could be further extensions to statewide or local orders related to eviction protections. Along with the court decisions, there have been some cases that have been filed by tenants against their insurers, especially those that have business interruption insurance. Unfortunately, the decisions so far have not been favorable as interpreting them to include pandemic in that. Usually business interruption insurance is going to cover when there's an earthquake or a hurricane and business has to be shut down and rebuilt or repaired and reopened. So far, not covering pandemic losses, but we'll see where things go from here. As you keep reopening your business and trying to come back, keep looking at these community financial resources. Go to your City Hall website for Oakland and San Jose, and then OEWD in San Francisco. And again, even if a program is currently closed, it may receive more funding and reopen. We've been mentioning the commercial lease consultations. These are 1 hour free of charge consultations where you can meet with a lawyer volunteer from the area. We've been conducting them on Zoom and by phone, whatever you prefer, but you basically sign up, you send over your lease and submit an application. You'll be paired with an attorney volunteer at a local law firm, and then he or she will reach out to schedule it, and you have an hour to talk about your situation and get advice. You can go also to the links here for Oakland-based businesses, as well as for businesses outside of Oakland. And again, we'll provide the content of the slides so that you have those links. And here are some other resources specific to locations. Here's the OEWD website I mentioned, SJE or sjeconomy.com. And then the Oakland website's a little more complicated, but we'll provide that to everyone. And then we'll open it back up for questions.
I don't see any questions, but I can go ahead and I know, Jake, that you mentioned a little bit about the services that we're providing, but I just wanted to make sure there was clarity that on the 2 links that I sent in through the chat, there is the first one being the general page for our information on the services that we provide. We provide free transactional legal services to low-income individuals and who want to start or develop businesses. And so the application for services is on the right, and then you can see there's a list, there's a Spanish one and English. And then the Oakland one would be on the page that I sent in the second link that has the Oakland services. And we'll be coordinating through an intake process. We'll be just coordinating, just gathering more information so we can match you with an attorney. Yeah, any other questions? I don't see any popping up, but feel free to raise your hand or send it over.
And there, if folks are thinking about what they want to ask, we did get some questions before the presentation today, so I've gone through some of these because I believe some of you are on the call, but in case it's helpful for other folks, or if the folks who asked the questions are here, We did cover whether the landlord can charge interest on back rent, even if you've been paying. Yes, the landlord can. Make sure it's only on the rent that you've missed, not on the full amount that was due during that time. If your lease is month to month and the landlord won't reduce the rent, so you're on a month to month lease. The landlord can't raise the rent in terms of what was in place on March 17th in San Francisco, for example. You know, since it is a month to month lease, you can always walk away as long as usually a month to month lease, you have to give 30 days notice. Not ideal if you're operating in that space and things are going well, but it could be leverage that you can use against the landlord and say, you know, if you don't work with me on this, I'm going to have to give my notice and close the business. And, you know, in that situation, the landlord again is not going to be able to find another tenant to sign a 2, 3, 5, 10-year lease, let alone a month-to-month one probably, or they're going to have to reduce the rent pretty significantly. So they can keep an existing tenant and maybe knock the rent down for a year, by a quarter or a half, and have some money coming in, or you can vacate the space free and clear, and they're left without much recourse because your lease ended and you were able to leave that month-to-month lease. They could still, if you have been unable to pay all or part of your rent since this started, then they would maybe try to sue you for the rent you owe. But moving forward, you wouldn't owe rent for the next 2 years remaining on your lease. So just it's a good negotiation tactic or option to have that a lot of others that have longer leases do not have currently. So keep that in mind. Another question was, can I get my deposit back if I cancel the lease now and haven't paid rent since March? So in California, the landlord can apply a deposit toward any missed rent through the end of the lease. We have had some tenants that have gone to the landlord and said, it doesn't look like my business is going to be able to come back anytime soon. So, here are the keys. I've, had the carpets cleaned, the premises is in good condition. There's going to be an argument about whether the lease was actually terminated. If your landlord is going to agree to let you out, at that time, that's the ideal scenario. But if there is back rent that was owed up until then, the landlord can apply that amount toward the back rent. If there is any rent left, or any deposit left over at that time, the landlord has to return that to you within 30 days and say you've been paying rent in full this whole time, and then handed over the keys, lease is ended. The landlord has to pay that deposit back less any costs for cleaning, repairs within 30 days. I think someone asked this earlier, mutual lease termination, the landlord has no obligation to give you a break on your rent. They do have to work with you, and as long as you're still communicating with them and doing what you can to pay rent. But the landlord doesn't have to give you a discount, doesn't have to reduce it, but they are prevented from evicting you, especially in San Jose, from any kind of harassment, trying to get you to waive your rights or trying to evict you because you're exercising your rights under the moratorium. San Jose particularly is good on that front, but keep trying to work with the landlord, making reasonable asks, and hopefully eventually the landlord will budge a little bit. And then there was a question about a landlord's responsibilities for inhabitable space. If the person that asked this question is on the call, it'd be helpful to get a little bit more context, but there's something that's called the warranty of habitability in many leases, and it's almost always a residential lease. And what this means is that the premises that you're renting have to be habitable. So that means you have to have heat, you have to have running water, different sort of basic amenities that make the space livable. And unfortunately in California, those do not apply to commercial spaces and commercial leases. So that may be a question for a commercial lease consultation, just to analyze that a little bit more closely.
There's one more question, Jake.
Sure.
It says my lease agreement rent will increase 4% annual. Right now, federal interest is 0%. Do I have any legal options?
So it depends on where you're located. For San Francisco, I mentioned that the landlord can't change the terms of the lease as they were in place at the time that the moratorium started on March 17th. And so if that 4% provision was in the lease at the time that all this started, the landlord, the lease still controls. It's just that your rent that's due under the lease for the remaining term doesn't have to be paid, and you can't be evicted for not paying it. You could see if the landlord would be willing to not increase the rent for this next year, or maybe hold back the 4% increase and then do an 8% increase the following year. It's all about what your landlord's willing to do. But if the lease provides for that and provided for it before COVID, then the landlord's able to do it.
That's all the questions that I'm seeing. I'll be sending out the link to the webinar that was presented today, as well as the presentation slides and information on how to request a 1-hour consultation for folks that were interested in that as well. But thank you everyone for attending. Jake, is there anything else you wanted to add?
No, I'll just say thank you to everyone for coming. I know it's a tough time, but the commercial lease consultations are a great way to at least have someone to talk to, which I know is huge right now, and just know where you're at. Please sign up for those. I'm more than happy to spend some time talking to you. Just stay safe and healthy, and keep going.
Thanks everyone. Bye.
Take care. Stay safe.